Hayal has taken us live. Hey, everybody. Happy Friday. We're back. I was in Tel Aviv last week and the week before, so I think maybe already 2 weeks that we haven't done our usual Friday privacy chat. One of my favorite guests always, our lead for global privacy, who has the challenge of keeping track, advising, counseling, discussing, educating, debating how countries around the world are implementing and developing privacy protections. Gabriela Zanfir-Fortuna is with me once again, and we thought we would talk a bit about an issue that we don't really know all the details about, but that doesn't stop us, because here we are, Twitter, LinkedIn Live, we speak, and maybe we think, and hopefully all learn a little bit. But let's jump forward anyway. We all saw, of course, the big news of an almost $1 billion fine assessed against Amazon by Luxembourg, which is the headquarters in Europe for Amazon, certainly from a data protection view, involvement from the CNIL, a fine that has gone through the EDPB process. So we have some notion that there's at least some kind of consensus that this is the view. And we don't know the full elements. We know that the French advocacy group that filed the complaint did raise many issues. Among them is, what's the legal basis for the advertising that Amazon does? Now, let's just level set for a second. Much of the debate about advertising and ad tech has really been focused on some of the big problems of this sector. And what are the big problems? Well, as some critics say, oh, it's a big data breach, right? There's many parties, third parties, fourth parties, real-time bidding, auctions, and it's been a challenge for the industry to show that there's a good chain of control and custody and commitments and promises that are made when this data is moving through all these parties and being swapped and sold. And of course, the issues of setting cookies and other things captured under e-privacy, and the revoking of that, and the details of so many parties being disclosed if you're going to be relying on consent, which seems to be necessary. So those issues are still obviously being debated, and we see lots of enforcements and investigations. But the assumption for many companies has been, many controllers, that first-party advertising, when you're not selling the data, that you're just using what you know as a publisher, what's going on at your site. People register, they put their name in, maybe they sign up, there's a subscription, maybe there's some data, are you male, are you female, maybe what you're purchasing at the site is going to be customized to offer you, more things. You bought certain kinds of sportswear, you bought women's clothing, so now I'm going to categorize you. And so the assumption has been that when you're not selling the data, sharing, throwing it into this giant, crazy ecosystem, that you're in a privacy safe zone. And in the US, of course, my assumption is all our European colleagues are hopefully on vacation, and only the crazy Americans are like sitting at their desks on Friday. Plus, it's in the afternoon in Europe. So let's talk a little bit from a US framing. In the US framing, we have all these new state laws that seem to make a point that sale is what's important. Sale of data. CCPA in California, personal information, you have an opt-out of sale. So again, the message has been sent by Colorado, by Virginia, by California. Yes, for some sensitive data categories, we're getting some opt-in some of the states. In California, you don't even get an opt-in, but you at least get a opt-out of secondary uses, and certainly a call out for ad tech. So it's not a surprise that for a lot of US companies, the assumption is, oh, hey, it's all good as long as I'm not selling the data, but the customizing that I do as a first party, that's my right. I know the customer. Well, of course, I was in a Slack channel with a lot of ad tech people the other day, and they were shocked to hear, what? Wait, maybe there's some issue if I'm not selling the data? Of course, it's my data. What do you mean? Why is there a problem? Well, of course, even in the US, there is a problem. We have consumer protection rules around deception, unfairness. You don't get to just do whatever you please, but typically something like customizing advertising based on your interaction maybe as long as there's not sensitive data, there's an assumption that this is a lower privacy risk. Of course, on the European side and many countries around the world that are replicating some of the thoughts of GDPR, the big distinction between even the strictest US laws is the notion of a legal basis. Gabriela, I know you and your team, when you analyze the different national laws, one of the first thing is, does this law require a legal basis? Collection is illegal, not allowed, unless you have a legal basis to even collect the data. Default, personal information, human rights. You have no right to do nothing unless you have a legal basis. Okay, so there are 6 well-known to our GDPR experts, of course, and 3 are the ones likely for most companies. The other 3 are more relevant to government or other instances, right? Legitimate interest, contract, and consent. So what's the relevant legal basis for first-party advertising? Now, a lot of companies just deal with legitimate interest when it comes to a lot of direct marketing issues. And they provide an opt-out, and they feel they're okay. So let's start perhaps with legitimate interest. And again, let's avoid for the second whether if you're setting a unique identifier, a cookie, and so forth, and that is your basis for targeting. Obviously, in the instance, we're in a world of consent. But let's assume this is not the case, right? I'm coming to read the news at the BBC. I'm at an advertiser, a commercial site where I've transacted, and there's going to be advertising, on that site. Maybe I'm Amazon, right, where I'm using data across all of my site based on different purchases. Amazon is now one of the largest advertising players because there's so much transaction on the site that retailers who want to push you to go to transact by them can advertise. Just like you go into a retail store, there might be end caps or different promotions that the Coca-Cola is paying for to get you to buy their product. So there's a huge fortune of money being spent on Amazon by retailers who are trying to push you to buy their product on Amazon. And so it's a first-party type of activity because Amazon is saying, hey, we don't sell or share the data. And this is the case with a lot of the other big tech companies who say, hey, we don't sell data. Yes, we use it in this very robust secondary set of ways. Facebook, probably the biggest example, using data about what you do at Facebook to let advertisers target ads and efforts not to target. Okay, Gabriela, over to you. So let's go through some of the challenges with the different kinds of legal basis here. And we have in mind Amazon. We have in mind there's this Facebook case. We have in mind every other company. A lot of people are looking and saying, oh, this is about Amazon. I'm not Amazon. I think our interest, we don't know the details on the Amazon case, is to say, what are we learning maybe about this Facebook case, about the issues at Amazon, about what kind of legal basis and how broad the uses can be when somebody interacts with a site. So over to you. Legitimate interest. I always mess up Frederick's last name. Borges?
Borges.
Borges?
If you're watching, yes.
He's with us? Oh, we got to grab him in.
I'm not sure if he's watching, but...
all right. We'll anyway, he's written very thoughtfully around some of these issues and even suggested that legitimate interest, at least when it comes to the third-party tracking and selling, would not be adequate because of what goes on. But walk us through the assessment for legitimate interest here.
There are a couple of things to unpack. So even if we talk of direct marketing, we also need to take into account the e-privacy directive, which speaks of different relevant things for direct marketing. One of them is, for example, email marketing. You need to have consent for sending direct marketing via email even, with some exceptions. One of them is whether you are sending it to potential clients that were already your clients, or about services to people that had already interacted with you. So that's when you can actually base this on an opt-out or legitimate interest type of, let's say, lawful ground. Then one key question to keep in mind is, what do you do for your direct marketing? Because what the EDPB and the European Data Protection Authorities have highlighted for a long time is that if you're engaging into profiling, that's very complex, and that relies on the data collected from sources all over the internet, for example. That's actually quite intrusive from their point of view, and it would be very difficult to meet the threshold for legitimate interest, because this means that to meet this threshold means that you need to make a balance, to draw a balance between your interest to move your business forward and the rights and interests of the data subject. If you think that there is some imbalance there, you would need to provide some additional safeguards to the data subjects, to individuals. And only after that, if you think you have reached that equilibrium, you can go on and rely on legitimate interests. So that's a bit of the challenge with legitimate interests. It would not necessarily be able to justify very, very complex processing operations involving collecting personal data from many sources in a way that's unexpected to data subjects. That's also very important.
There's like a context and compatibility notion that is in many ways part of a legitimate interest discussion.
Yes, indeed. Yes, absolutely. So that's really one of the biggest challenges, and this is why we've seen in practice, a bit of a shift when we're talking about direct marketing and targeting advertising on your own platform. And most of what we're seeing out there now is that it's either based on necessity to enter a contract. That's most of the times actually. When you're requiring an online service, or on consent. This is also some of what we're seeing now. Perhaps
so
the question
before we drop legitimate interest completely as an option for targeted advertising, I wonder whether there might be some distinctions, though, pulling in third-party information from the internet. I think the EDPB and its social media guidelines, talking specifically about the kinds of very robust data, what you like, and these sorts of things that Facebook might be using. They raise the question that it clearly might be a challenge to do that on legitimate interest. But there may be typical companies where what's going on is really not that robust, shall we say. Perhaps I purchased a product, and now I'm coming back to the retailer. I'm logging in. I'm aware that I'm in this direct relationship, and I'm offered a product based on my previous purchases, right? Or what's in my shopping cart, or maybe even advertisers are offered. Let's take again the BBC, just as an example of a publisher. And my understanding is the BBC's advertising outside the UK does use third-party ad tech and so forth. And frankly, for a lot of publishers, this is the case. But we know a lot of publishers are trying to pull this in-house and create their own first-party situations to sell to their audiences, to advertisers, without using all the ad tech in between, or licensing and trying to minimize the sharing of data. So they might be using things like, I registered, I may have provided actively some information. Maybe I was asked some age or other stuff, or maybe the advertiser assumes some things about me based on my purchases, or maybe they even append some data, right? But let's assume a modest targeting of advertising. Cookies are aside, I'm logged in. It certainly may be clearly possible that, shall we say, modest targeted advertising on a first-party type basis would be compatible marketing purposes, that you could do a legitimate interest test and say, hey, but of course, you would need to provide the opt-out And this is not something that obviously many, certainly if it was obligatory that Facebook would give you an opt-out of Facebook's advertising, many people might say, yeah, I don't want it. And this would be perhaps a challenge for the business model, or maybe certain degree of advertising would be allowed on a more modest basis. But even then, it's legitimate interest. You have to do an opt-out. Okay.
Yeah, no, that's a complete yes. And even the EDPB in the social media guidelines, they say that in general, the two lawful grounds that you can use for targeting on social media would be consent and legitimate interests. So you just indeed need to be careful on the context and from what are all of the sources where you gather the data, what type of profiling you're engaging in. But yeah.
Yeah, so legitimate interest still on the table, not for the biggest robust type of activity, perhaps where profiling and other risks to the individual are involved, but an opt-out required. And for companies whose business model is very dependent on only advertising, that opt-out from even first-party activity could be a very significant issue. But again, a lot of them are currently relying on all the third-party ad tech and already offering an opt-out, or are using cookies and already working with an opt-in. Go ahead.
Yeah, no, actually, I just recalled something. We do have very, very few details about this record fine. You were absolutely right. But we do have some details from a letter that the complainants received from the CNIL, their own data protection authority. And one of those details is that the decision imposes on the controller to provide an opt-out. So that's quite interesting. It's like the last bullet point on the list, and that's one of the requirements. The controller needs to provide an opt-out for all processing that has a direct marketing purpose. So that's quite interesting, which I think leaves legitimate interest on the table.
We did hear from somebody close to the process that the position that the EDPB and the Luxembourg authorities put out didn't make a decision specifically on legal basis which one must be used. So we need to really understand and see that before we get too far ahead. But a clue, as you note, if they're saying opt out, then that tells us that legitimate interest is apparently what is being directed, although obviously with contract and withdrawing consent and so forth as well. Okay, so let's move for, I don't think we need to discuss really consent, right? Because probably that's what is remaining if contract doesn't work. And of course, consent has its parameters of having to be very specific, and also, of course, being able to be withdrawn and so on and so forth. So let's move to contract, because this seems to be where some companies are going. It seems to be where Facebook appears to be suggesting that agreeing to the terms when you sign up for Facebook, that there's now a contract involved. And we have some, and of course, with contract, you do not get an opt-out of certain terms of the contract that you have agreed to if it's actually a valid contract. And presumably Facebook or other companies like that who say, this is how I make my money, I don't want to offer an opt-out of this. This is part of the deal. We are a personalized advertising and social network. We are a media site if I'm a publisher, and a media site means there's advertising. It's part of the it's part of the discussion. And as a result, we don't expect to see people choosing to dismantle, but it has to be necessary for what the individual is contracting for. So let's think about contract. And again, we have some guidance here from the EDPB's social media and from language around contractual necessity. We know, for instance, that the EDPB has advised that product improvement, which you would think is really part of a contract. I was a bit surprised, maybe naive. You contract for a service, obviously maintaining the service, this is part of it, but improving it is really very tightly tied But the EDPB view, and whether this is really fully the prevailing view across all the DPAs, I don't know if that's the case yet. We'll see. It hasn't been, I think, really tested. But they said, no, you need a different basis. And of course, the implication of needing a different basis, legitimate interest or consent, means it's revoked, although maybe not, right? Legitimate interest, you're guaranteed revocation when it's a direct marketing. It could be that companies could say, it's my legitimate interest to do product development, and no, the risk is low. No, you don't get an opt-out. I can object to that, right?
Yeah, sometimes you can overturn, well, the not the one for direct marketing, but the opt-out, the general right to opt out for any processing when it's based on legitimate interests. The controller can overturn the objection of the data subject if it has a compelling grounds. That's what the GDPR says. But not for direct marketing, though. The one for direct marketing is a blanket, opt-out. Yeah, on the contract, that's actually so relevant for a case that we're seeing out of Austria that Max Schrems brought before the Austrian courts, and that has exactly this question on the table. Can this type of advertising be tied to an online services contract, or can it even be the object of the contract? Because I was looking into the case the other day, and in fact, after the court of first instance, then the case went to the Court of Appeal, and the Court of Appeal actually considered that the contract with the user and the social media platform was a contract of personalization, if we are to believe the automated English translation. And the Court of Appeal thought, well, this type of targeting is necessary for a contract of personalization. Now, what the Court of Appeal decided was brought before the Supreme Court, which I understand that is the court of last instance in Austria. And then the court of last instance was not convinced either way, and just very recently sent questions to the Court of Justice of the European Union to interpret this particular issue of what type of contract do we have there between a social media user and the social media provider, and what can be covered by that contract as a lawful ground for processing personal data. So that's going to be a fascinating case, I would say. But we know the timeline at the Court of Justice is not the quickest. So let's see where that goes. Yeah.
And in fact, you've seen Facebook over the years updating its description of what it is as a service. I noticed somewhere the other day that it was like, a social network plus personalized advertising, like they were doing something in some of their descriptions to make it clear that this is the bundle. But whether or not the courts would say that what somebody is contracting for, when I contract with a business, when there are data enhancements, to it, whether or not because of the special nature of human rights and the importance of personal information, whether you can evade other restrictions that the GDPR appears to seek to give an individual by simply bundling it into the contract and saying, all these alternative uses are part of my deal because this is how I presented it to the user, right? Come here because I sell your data and I'm giving you some commerce. No, I'm clearly here to transact, or for my social media. When and where does a business get to define its purpose? And presumably you could define your purpose, but you would probably need to say, hey, come here for us to sell your data. Come here for personalized marketing. Come here for coupon, right? I mean, there are obviously sites that are all about commerce. Come here and we're going to give you, offers based on what you tell us you like and this and that. But can you sneak your main business into the, can you really claim that this bundle is defined by how you choose to describe what you do, when we know that the essence of what you do is really commerce? Or is there a long history that advertising and media go together what's the boundaries here? So this is a really huge question, I think, that the court is going to have to grapple with.
Yes, absolutely. And then, we also kind of enter, if we are to start talking about a contract of personalization or how we want to, describe it, we are also entering the realm of contracts in law. And we know that that's a really vast area of law. And, we're talking about validity of contracts here and the what could be a vice that would invalidate a contract. So it's really a case like this really goes to the core of how data protection as a legal field starts interacting with the other legal areas that are very relevant to it. And unfortunately, we haven't had a lot of that in courts yet. So this is kind of uncharted territory. And this is what makes this field fascinating for me, at least.
Interesting. That's true. How much will EDPB really look to the fact that there's a lot of legal, maybe not with specific regard to the personal information GDPR issues, but contracting and disputes about contracts and what are primary terms and how you invalidate. We have lots of history around that. How will EDPB, well, we've seen EDPB already come in and say, no, when it comes to data, you cannot bundle, product development. You cannot bundle advertising and marketing into a contract. And so I assumed immediately when we saw a little bit of the coverage of the Amazon case, understanding where, some of the data protection regulators have been going here, that this was the issue in hand. But again, we've heard from some, who've been in some of the rooms that this was not a clear finding. But I guess we'll have to look closely at that. Sundeep Kapoor says in the comments, is the regulatory authority's position that targeted advertising by publishers is direct marketing, right? And I think we've seen them take that position, but there's a reasonable argument that, when I publish content. And if I'm a retailer, for instance, my other content is other commerce, and I'm clearly, selling things to you. Or even if I'm a media site and the, ads are adjacent, that this is, not direct marketing. Direct marketing is putting an email in your box, doing some intrusive individual thing, but this is individualized clearly to a user. Do you have a reaction to that question? Is there argument that
there's no black and white answer to that, Sandeep? There's really no black and white answer. You have to look into the guidelines or Q&As that the specific data protection authority that has your processing under their supervision and how they're looking at it. I know, for example, I hope I'm not mistaken, but I think the ICO does take this position that targeted advertising direct marketing includes the targeted advertising by publishers. I hope I'm not 100% sure. So this is why I'm saying you really need to go and check the DPA that you're interested in.
And Gabriela, again, this is a place where there might be a distinction between the whole third party, right? So if somebody is tracking me wherever I go, without regard to even what publisher I'm at, and targeting me based on a cookie, an IP address, something, is it really different than putting an email in my inbox or a text or a phone call when someone is using the internet architecture identifiers, an IP, a cookie, and so forth, to target me and personalize a message to me wherever I show up, right? That really looks just like another way to do direct marketing. However, you can see more narrow things where I'm logged into a company and they're showing me their product, and the fact that there is personalization of both content and advertising and algorithms that are determining, what's happening on the page. Is this really part of publishing and personalization? So maybe there'll be obviously different opinions on it. We also have an interesting issue raised in the comments, imbalance of power.
Yeah.
If contract is involved, how is imbalance of power?
Well, this is, I'm sorry for cutting you right there, Jules, but this is why this is so fascinating as a legal question, because if we go to the contract real, then we have to talk about lack of capacity, who can actually enter these contracts. We can talk about misrepresentation during the negotiation process, because, whoever enters the contracts needs to have a proper representation of what contract they're entering into. So this really opens up, I would say, a whole new world for data protection discussions.
Another issue that's been raised in some of the discussions around contract is, what does it require to make a contract? Eduardo Usteron was posting the other day on Twitter, around some of these requirements that have been read as a very explicit, statement and so forth. I think he was talking about, consent. If I'm just giving my data, am I consenting, or do I need to read back to me? You're giving in the data now. Do you consent to giving it in for the purpose? But when it comes to contract, the issue that's been raised is, hey, you have a pop-up. Like, where is there a contract, right? Is a contract, a piece of paper, and there's terms, and I agree to the terms. I sign. I do things. That's a contract, versus what we call in some jurisdictions, the click wrap. You agree to a whole page of information by clicking here, scroll down, and now you've agreed to 100 different things. Is this really a contract? And we've had, certainly in the US, different courts taking different positions, some saying, yeah, in this digital world, this is how you agree to a contract. We want to make it easy for you. I don't need to DocuSign a document. Others have said, this is not a contract. Maybe it's consent. Maybe it's consent. But how is it a contract when you simply are clicking on, a terms of use?
Well, yeah, I mean, I don't have much to add to that. Yes, indeed. So I think we're just at the beginning of a very intellectually stimulating journey, to figure these things out. And finally, courts are starting to pay attention to them. And we're finally starting to see some judicial decisions.
Great. Well, we only want to take a little bit of your time today. Is a little coffee chat to share some of the issues that we're looking at that I know many of our stakeholders are interested in. So, of course, you might get our email if you would like to accept direct marketing from us of our information and knowledge. You can sign up at fpf.org, and when we put out our more thoughtful and structured information and so forth, you will get it in that manner, and of course object to it at any time. And Gabriela, thank you for taking the time. I know a busy day, and thanks to all who listened in. We also have a great training program for those who want to know, how does this ad tech stuff really work? What about biometrics, the identification? So you'll see it at the top of fpf.org, where we put on a number of courses that are aimed at data protection experts, but are not really about the law. We think you're all smart and know about the law and have plenty of places to read that. It's the technology and the data flows that really need to be well understood, and we try to give a real honest, detailed understanding of the data flows and so forth, since this is what we think and talk about all day. Have a great weekend. See you soon, Gabriela. The rest of you, thanks. Look for our regular chats on Fridays on topics of interest. Bye all.
Bye all.
Thank you for helping make things